Before I go further, my name is Dolly Makole, as Sonke indicated. So this event has been especially designed for procurement practitioners, public officials, and anyone involved in public procurement processes.
And good afternoon, everybody. Good afternoon, colleagues. Thank you for this opportunity, which I do not take lightly. This is a responsibility to try and get across to you probably one of the most important pieces of legislation that not only the public procurement fraternity is going to have to deal with, but actually South Africa. And as I run through that, you'll start to see why this is such an important piece of legislation. Let's kick off. So public procurement in South Africa is almost R1 trillion. That's R1 trillion. That is R1 million is spent every year by the state on procurement. That excludes salaries and wages. This is procurement spend, R1 trillion. And it's spent by over 720 different procuring entities across the world. Now, very different in public procurement is we do not just focus on value for money. There's always other strategic, broader policy outcomes. And this is a picture from an organization called OECD. We do not have a similar picture in South Africa, but you can see that public procurement doesn't just focus on value for money. It's green, it's support of small businesses, it's support of women-owned businesses. There are many other different policy outcomes for that. Now, one of the big changes you'll see is that in 2015, we were described by National Treasury as being very focused around supply chain management. Supply chain management was an umbrella term that included procurement, contract management, logistics, disposals, the procurement, the post-procurement, and everything was termed supply chain management under that supply chain management umbrella. That is changing. We are moving back towards a world in the public procurement space where we're going to be talking about procurement. The odd thing is that procurement is still going to mean what we have come to know as supply chain management. Now, almost 11 years ago, Professor Pino and many others were requested for input on a new public procurement bill. In 2014, Treasury directed National Treasury, the Cabinet directed National Treasury to put this together in December 2014. And in 2015, the Office of the Chief Procurement Officer said, hey, we will get something out quite soon. It will be circulated for comment early in 2015. Well, 5 years later, in February 2020, we finally saw a version of that. It was put up for comment. The comments closed sometime in June, and there's been a process that's been followed since then. In October, after they had received and reviewed many of the comments that they received on that first draft that was issued for public comment, they put out a timeline, which basically saw us having the bill being passed by Parliament in November 2022. That was eventually passed by Parliament in May this year and sent to the President for the President's signature. So 2 years. Why the delay? Many issues happened within the public procurement space. One of those was the big Agribusiness case. The other one was the report by the Zondo Commission, and many of those things required a lot of attention by the public procurement community in that, and that might be some of the reason for the delay. Where is the bill now? It has not yet been signed by the President. It is sitting on his desk. We know he has a pen. We know he has ink in the pen because he's been signing other bills. This one has not yet been signed. Can he sign it now that the new Parliament is in place? The answer to that from many of the legal folk that we're working with is yes. He has, anytime he wants to, he can sign this bill and decide when the bill will be effective. When will it be effective? This is not an official perspective. This is Shaun's perspective. I do not think that this is going to be effective until middle of next year, if we're lucky, possibly late in 2025. Why? Because there is a lot of work to be done before we're anywhere close to understanding what we put into our policies. Yes, there's chances that we might be able to take aspects of the bill and stagger the implementation. Certainly, we need chapter 4. We'll talk about 4, and chapter 5 is more urgent, but those two require quite a lot of work to be done as far as the regulations are concerned. There are in fact, I checked last night, there's 66 references to regulations in the current version of the bill, 66 places that say we need regulations for this, we need regulations for that. Very differently to what we've had in the past, is those regulations are going to have to be consulted on by the Minister of Finance with the responsible ministers. And at this point in time, I can't think of a minister who they will not have to consult with. It will go out for public comment. They will have to receive the comments back. They'll have to engage often on those. They'll have to report back on the consultation that happened. Once it's been approved by Treasury, it will then have to go to Parliament, just as we've had with the bill, and follow the process through the two houses before the regulations are going to be approved. It's going to take some time to get that done. We will see aspects of the bill, such as the tribunals, which might even come far later than late next year. And that's because there's no funding at the moment, and the time that it will take to put the tribunals in place will be well after the effective date is concerned. What is the big impact? What is the change? Well, there's two pieces of legislation which will be repealed in its entirety. I'm not sure why they haven't been repealed years ago. The Tender Board Act and the National Supplies Procurement Act, those two will be scrapped entirely, as well as, very significant, the Preferential Procurement Policy Framework Act, that act that's been out for 24 years, that will be scrapped in its entirety. There are many, many, many other acts where there will be some changes. Two of those big ones is the Public Finance Management Act will be amended. There are only 2 paragraphs, interestingly enough, that will be fixed. And those 2 paragraphs will be taken out of the PFMA, and the PFMA will no longer be the governing act for procurement in the PFMA entities. The Municipal Finance Management Act, local government, similar thing. There will be a section that will be taken out, and Municipal Finance Management Act will focus on finance. The Public Procurement Act will focus on procurement. What's the bill meant to do? Regulate public procurement, prescribe a framework within which preferential procurement must be implemented, and to provide for matters connected therewith. You're starting to see the focus and the emphasis of this bill. A framework within which preferential procurement must be implemented, and to provide with matters connected therewith. Quite interesting. The bill goes through, obviously, and we're pleased. It mentions 217, 2171, 2172, 2173. We'd be surprised if it wasn't there. The surprising thing is it also refers to, for the first time in legislation in procurement, section 216 of the Constitution. And you'll start to see here that there is a message coming through which we've not heard before. For the first time, there's a push for uniform Treasury norms and standards in procurement, and they're referencing a section of the Constitution, 2161, that says they have a responsibility to ensure uniform Treasury norms and standards. 195, 1 and 3, there's no surprise there. What's very interesting is the bill also recognizes the need to increase capacity of organs of state. And the NCOP, in particular, the National Council of Provinces, was very, very critical of Treasury to say, how can you say that, but not recognize that there's a financial implication for that? It will be interesting to see how Treasury responds to that and takes that forward, because they were requested to understand what the economic issues are as far as that's concerned. But very interesting. The aim is a single framework that promotes technology and combats corruption. That's interesting. In order to create a single framework, are you getting the messages here? Consistency, uniformity, single framework. Very, very interesting. Now, the draft that was issued in 2020 was cut down significantly. We now have about 35 pages in small print of an act. Now, let me pause there briefly. In the PFMA, at the act level, there is 1 2-line paragraph. The triple PFA at the act level is 3 pages, depending on the spacing of that, 3 pages. At the act level, we've got 3 pages in a paragraph. From a PFMA perspective, the PFMA entities in the country will be faced with an act which now has 35 pages. The quantum is significant. It started off very, very broad, which it included infrastructure, disposable assets. The infrastructure and disposable assets have been taken out. The supply chain management has been taken out. It's all been put into this one chapter 5 called General Procurement Requirements. So very interesting that change. So it certainly has said, we're going to put this act out there, but there's a lot of detail that will be coming later. Who will the act apply to? I can't think of anyone it will not apply to, with the exception of the parliaments and the provincial legislatures. The only aspect that will apply to parliaments and provincial legislatures is Chapter 4, the preferential procurement chapter. Very interesting. So every one of the public entities in the country, whether it's Eskom or Transnet or the small municipality in the remotest part of the country, this act will apply to them. What it does is it sets up a public procurement office, and it gives that public procurement office legislation, which interestingly enough, we've never had. The OCPO was there by name, but there was no legislation. There was no empowering legislation to give the OCPO any power. The legislation referred to National Treasury, not the OCPO. This now is going to empower this public procurement office. One of the big changes from the February 2020 draft that was issued was that draft was going to set this up as a regulator. It's now moved back towards an office within National Treasury. Interesting. Chapter 3 has a very big focus. Now, this is in the act, folk, right? Right now in the public procurement world, we've got a code of conduct that was issued under an instruction and circular, which we need to consider. We have pages in this act, a primary legislation level, talking about codes of conduct, procurement integrity, debarment. Interesting, it's going to extend to everybody. Right now, in the public procurement world, it's only the supply chain people in supply chain that have to sign the code of conduct. This is going to apply to everybody, from board members down to the role players in the different bid committees, much wider than currently. It brings into the bill this notion called debarment. Now, currently we refer to it as restriction. That's where supply is restricted from doing business with any organ of state. The one popular one was a big consulting company. Bain Consulting was recently big all over in the news around being restricted. The Act talks about the process for debarring. We could spend probably a few hours talking about Chapter 4. Chapter 4 is the chapter that will replace the Preferential Procurement Policy Framework Act, the Triple PFA, the Preferential Procurement Policy Framework Act, that piece of legislation that talks about 80-20, 90-10. Chapter 4 is going to replace that. What's very interesting is that you will see as we go through in the framework that there's something missing. If we look at the framework, and the framework essentially is on this particular slide, it talks about a mechanism in 2A called setting aside. Right now, in public procurement, if you were to ask a procurement official, can you set aside? They say no. There was a practice note that issued that prohibits the use of set-asides. This act is going to provide that very powerful mechanism. What is a set-aside? Well, we're going to set aside this contract. For example, we're going to set aside this contract for Black women-owned companies in Soweto. Right? That's a set-aside. Very interesting is we've heard out there that because of that Afri-Business case, that this is not legal, it's not lawful. If you go back to that Afri-Business case, why the pre-qualification legislation was declared unlawful, it was because it was not in the Framework Act, the Triple PFA. This replaces the Triple PFA. This provides the framework and legitimizes the use of setting aside as a legitimate mechanism in public procurement. In addition to set aside, they're also going to introduce another mechanism called pre-qualification, very similar to the mechanism we had in 2017. And we will also then have, which is the section 19, a mechanism called subcontracting, very similar to what we had in 2017. That's the mechanism. What's interesting is they will prescribe by regulation thresholds for set aside. So they particularly will say it's all transactions up to this value must be set aside. See the word must be set aside. From that point upwards will be pre-qualification to a threshold. We don't know what that will be, pre-qualification, very similar to Regulation 4 that we had in 2017. And then above that will be compulsory subcontracting as a condition of bid. We tried very hard to push against that as a mechanism, a condition of bid. We wanted to be a condition of contract, but we didn't quite get that achieved. Then we have local production and local content, which is very similar. That makes a return now in this one, very similar to what we've had in 2011 and 2017. And if I was to tell you, there are a couple of other things. I haven't shown you everything yet, but if I was to tell you that that's it, that's the essence, that's the materiality of the framework. Some of you might look at this and start saying, but where is the equivalent of the 80-20, 90-10, even if it could be 60-40 or 70-30? There is no mechanism for that kind of preference procedure in Chapter 4. Let's move on. Chapter 5. Very interesting. Very, very, very interesting. We're moving into a legislative environment in public procurement where methods are very under-legislated. Everybody uses panels. There's not one piece of legislation. In fact, there's not even an instruction that Treasury has issued on how a panel should be specified and should operate, but yet everybody uses them. What Chapter 5 says is that this bill will prescribe by way of regulation the methods and procedures that will be used for procuring goods and services. You will not be able to use a mechanism or a method for procuring goods or services which is not being regulated. It's going to be a very different space that we're moving into. Another big area that we can talk about, there's a lot more, by the way, in each of these. I'm just going to give you the key points. Big area is the Public Procurement Office. That office at National Treasury must develop and implement not many, a procurement system. Very positive that information communication technology is built into this. Very positive that it's in there. Some are wondering and are concerned as to the PPO's ability to put in place a procurement system that will satisfy the different diversity of methods that are needed out there by the massively diverse set of public sector companies that we've got with a single system. Going to be very interesting to see how that goes. Very new is that a tribunal mechanism will be included, which will give suppliers an ability to challenge a decision that was made by a procuring institution without going to court. Right now, it's expensive for a supplier to challenge a decision. They're not happy with your decision or your response as to how you've given it to a particular supplier. Their only option is a court process. For suppliers, that is extremely expensive because public organs have the capital to challenge. Once a decision's been made, they can ask for that to be appealed, reviewed. Those mechanisms are expensive for suppliers. The tribunal mechanism, which is effective and in use in KZN as we speak, is something that will be rolled across the country at a national level and throughout. And there will be an ability then for suppliers to fast track those without necessarily getting into the costly court processes. I'm almost complete. The regulations are mandatory for a range of requirements, many of which include things that we've never had before. We've never had regulations on competency requirements. I'm a bit worried as to where that will come from, where the content will come from. Perhaps that is a role for CIPS to do. There's going to be regulations on the security vetting of bidders. I'm really, really worried about that one. We hope the regulations are very clear that it's not every bidder that has to be security vetted. Can you just imagine the difficulty in that process? But there will be a range of regulations that are going to have to be issued. And there's a massive amount of work that needs to be done before those regulations are complete, consulted on, applicable, and everybody is happy with them. There are also some areas in the bill where it will be optional to have regulations, and the Public Procurement Office does not necessarily have to do all of those as regulations. So regulations regarding lifestyle audits and things like that will be optional as far as the PPO office is concerned. Many others will not be. They will have to do that. But as we said up front, the Minister of Finance is going to consult with the ministers on the drafting of the regulations before they're published. Very, very interesting, that process. It's going to be a very different world where for a long time Treasury has just issued out a draft for some comment, and then they say, well, this is it. We've now decided that this will be the instruction going forward. They must be published in draft, they'll be sent out for comments, etc., and then sent to Parliament as reviewed before. Folk, that's it. It's 35 pages. I've taken a couple of minutes to go through it. This is the Public Procurement Act of 2024. As soon as the President signs it, then I'm sure we'll have a lot more certainty on when this will be effective. But a very significant piece of legislation which will have a significant impact on organs of state, on public procurement practitioners. And I'm looking forward to listening to Thandy Pino when she starts to unpack what some of those implications are.
So what are your thought process around the main regulations or acts which governs the procurement and SCM environment? Do you think that there might be a need to review a constitution or PFMA? Yes, I heard you spoke about the possibility of scrapping the triple PFA, which I think as you were going through the presentation, some of the areas are incorporated into the bill. Do you foresee a review of a constitution and the PFMA?
Would you like me to respond to that now, Dr. Makole?
Yes, please. Just a few.
Yes,
yeah.
Sure. So, look, there's probably a reason for looking at the Constitution. I don't think personally that the Constitution needs to be re-looked at. We have a very, very powerful statement in section 2172 of the Constitution, and 2172, which we need to unpack a lot more as a procurement community, says that subsection 1 does not prevent the organ of state from implementing a procurement policy which provides for categories of preference in the allocation of contracts. Very powerful, right? So nobody can say that the Constitution says you have to be fair, It says no. We can ignore those provisions in subsection 1 as long as it's within the context of a framework. So that's the Constitution. I do not see that being changed for some time. It's unequivocal. Dr. Makole, the Triple PFA, when this is effective, the Triple PFA is dead. It's gone. It's buried together with its regulations.
Yeah.
The 2 paragraphs in the PFMA, which will be taken out of the PFMA and repealed, those 2 paragraphs give the power to the regulations under PFMA, Treasury Regulation 16A and Treasury Regulation 16, the equivalent regulations under MFMA. When those 2 paragraphs in the PFMA are scrapped, the regulations are dead. They're gone. Every instruction that we've got right now does not apply. When this is effective, it is a new game, a new area that we're going to be working in. There might be an opportunity to take some of those regulations and re-script them and redraft them and put them under this new act, but it's not going to happen in the same way. For example, the public-private partnership regulations right now are 2 different sets of regulations, one for PFMA, one for local government. We will not have that. We're going to have one act. So yes, it might in the majority of the shape that it's in move under the new act, but it's going to have to be redrafted. It's going to have to be consulted on again. It's going to have to go through the different houses of parliament before we can get there. I hope that helps.
Do you think there are barriers to the public procurement bill which is being passed?
Are there barriers? Massive barriers, finance, capacity. I mean, this is going to put a massive strain on an organization which a community, if you like, is very comfortable doing panels without having any regulation or legislation that governs them. They're going to lose that. So the mindset, the capacity, the training that we need, the competency that we need to deal with this is going to be quite so the key barrier right now, I think, is going to be the capacity at National Treasury, at the Office of the Chief Procurement Officer, and likewise at the different provincial treasuries.
Okay, thank you. So I'm going to be talking to the practical implications of the bill. So basically, I'm going to be talking to what we are currently doing, and then should the act be approved, how will that impact the way we are doing things? Firstly, the definition on the bill. For the longest time, we never had a definition of emergency. We moved from emergency being catering to life-threatening and everything in between. So currently now we have an act that outlines what is the definition of emergency. Secondly, the panel, we use panels a lot on framework agreements, body shops, etc. But now a word of caution is that a panel has been described on the act as panel, meaning that the tribunal constituted in terms of section 45. So meaning that you can't then use a panel in your policy for any other thing except a panel as defined in the act. Then the advice would be then rather use framework agreement or something similar. And then also when you look at transversal term contract, it now means a contract arranged by a relevant treasury or another procuring institution. What we know mostly about transversal contracts is that they're done by National Treasury and Provincial Treasury. And usually when we talk about relevant treasury, on most instances, we're referring to provincial treasury, but also do note that when the definition says or another procuring institution, that's where your national treasury, your CETA and other procuring institution will fall in that category, meaning that there hasn't been a change in terms of how transversal contracts are done. It's just that the way they packaged it. And then Shaun talked about the application of the Act. We're no longer having organs of state, but instead the Act makes reference to procuring institutions, and procuring institution is what we term as organ of state. And then section 3.1 then will list those procuring institutions that are applicable, or perhaps that this Act is applicable to. Now, one thing that also has changed in this act is that the Office of the Chief Procurement Officer is now, Chief Procurement Officer is now called the Head of Procurement. And what is currently still actually continuing with the current practice whereby National Treasury and Provincial Treasury usually issue binding instructions to departments and SOEs. But for municipalities, they only become legally binding if they're adopted by council. So if you look at subsection D, it does say that after consultation with the relevant category of procuring institution, we determine the, sorry. This one actually talks now to the model policy. Model policy, there's always been that question to say, when we get a model policy from National Treasury, must we adopt it as is? Are we allowed to change it? Are we allowed to have a different policy? So subsection D actually clarifies that now you have an option to either adopt the policy as is, or you make amendment to it, or not adopt it at all. So the model policy is purely a guide from National Treasury, which you have a choice to take or not to take. But also this section 5. Subsection 2 and 3 also talks to the issue around the municipalities that are not actually required to follow instruction from the provincial National Treasury unless if they are adopted by the municipal council. In case of the entity, they're adopted by the entity's parent municipality. So this is basically something that is still currently happening. And this also makes reference to provincial treasuries as well, that even if they issue a gazette, it's not applicable to the municipality. If you look at section 6, where I've highlighted Roman figure number 3, it says that a provincial treasury may within the province enforce effective management and transparency in respect of the procuring function of procuring institution except municipalities and municipal entities. So basically, like I said, this is still currently the same as the way things are happening with the current legislation. One thing that has always been a challenge in the procurement spaces, procurement practitioners, is receiving illegal instructions from our bosses, for lack of a better word. Could be a politician, accounting officer, CFO, anyone. So now the Act is coming out right to say that you may not implement that particular instruction. And you, as being the affected person, you must inform the Public Procurement Office or the relevant provincial treasury in a prescribed manner of the direction, objection, and the reason for objection. So you might get an instruction from your supervisor of which you're of the view that is in contravention with a legislation. You will then not implement that instruction, but also you need to further report to the Office of the Chief Procurement Officer pertaining to that. And then if you look at number 4, lastly talks about the affected person may not, despite any term of employment, be subjected to occupational detriment. A lot of times, the reason why we end up implementing these instructions, we like to say, put it in writing, at least I won't be charged for insubordination. So that will not surface anymore. If an instruction is not compliant with the law, you're not supposed to implement it, but you also must take it further and report it. And now we know that you're not going to be a disadvantage in any way. And this is also making reference to the Protected Disclosure Act. And then Shaun spoke to chapter 4, which is preferential procurement. In a nutshell, 2017 regulation is making a comeback. But what is interesting about this, if you look at subsection 2, it says that the procurement policy of the procuring institution, referred to subsection 1, must provide for setting aside bids in accordance with section 17. And if setting aside in accordance with section 17 is not possible, then you pre-qualify. Pre-qualification in accordance with section 18, and then if the procurement in accordance with section 17, 18, 19 being subcontracting as a condition of tender is not possible, the procuring institution must record and report the reason to the Public Procurement Office and the relevant treasury. So if you can't comply with section 17, 18, and 19, it needs to be reported. So it's not an option anymore. You have to do it. If you can't do it, you need to report it to the relevant structures. And this is basically now talk about the pre-qualification in terms of how it's done. It's still the same as 2017 regulation, but this is at an Act level. And then in the regulation, it will be prescribed in terms of the different percentages that one would have to pre-qualify. Local content. One thing that's very interesting that I'm picking up about local content is that now this Act is bringing a new minister into this particular legislation. We know that this Act belongs to the Minister of Finance, but now with local content, now the Act, it says the minister responsible for trade and industry and competition must by notice designate a sector. So it's not going to be the finance minister, it will be the Minister of Trade, Trade and Industry. And then what will then happen is that the minister, the designation and stipulation as envisaged may only occur after the responsible minister has. I think with the whole situation of the 2017 regulation being found to be unconstitutional, we've seen in terms of also the relationship between these ministries and different organs of state. So now sometimes one would think that because local content is a requirement for me as an organ of state or as a procurement institution, I need to implement it because the regulation says so. This one, you need to be very cautious that it needs to first come from the Minister of Trade of Industry. If it doesn't come from that minister, then you cannot implement it. And then also, if you look at section 6A, it says that if the required quantity of goods subject to a designation in terms of subsection A cannot be wholly sourced from local manufacturers or at the designated local content threshold for the period designation or both, procuring institution may submit a request for a waiver. This is where now you are requesting to the minister to not implement this particular requirement. I found it quite odd to have this kind of a section, meaning that does it say that there will be instances where a sector will be designated whereby it will not be possible for such to actually take place? Because that's basically what this section is saying. The responsible minister must within 30 days respond to the request for a waiver, giving reasons for the decision, failing which approval will be deemed to be granted to the procuring institution that made the request. So you make a request for a waiver that I cannot implement a designated sector of furniture for whatever reason. And then within 30 days, the Minister of Trade of Industry must indicate to you that, okay, we are approving your waiver. If the minister doesn't, then you proceed. So this, again, it's making me feel a bit uncomfortable again with local content, but it is what it is. Again, chapter 4 talks to the condition of contract. We know that subcontracting is a condition of tender, but also there's now an additional to say that as a condition of contract as well, a procuring institution may, as prescribed, provide for measures of preference as a condition of contract that the supplier must achieve at the end of the contract. So basically on contracting, you might say to the bidder, when this contract ends, you must have empowered 20 youth, or you must have created jobs for this particular women, or whatever the case may be. It will be a condition of contract. And then these future deliverables must form part of the contract with set milestone to be achieved together with the penalties. One thing that always miss a lot in our contract is actual penalties when it comes to non-compliance with these conditions. So now it's an act matter that you need to also put penalties should such condition not be complied with. Then here it talks about a reconciliation of the word. I think Shaun spoke about it. But basically what I want to highlight on this one, what is currently happening in our environment is that when a bidder is not happy with the decision of the organ of state, they will go straight to the courts and then they will litigate. But now the Act has created a hierarchical structure whereby first the service provider needs to go to the organ of state. If they're not happy there, they go to the tribunal. They're not happy there, then they go to the courts. But what's very interesting about this section is that firstly it says the tribunal or a court may not review a decision to award a bid unless the bidder has exhausted the internal remedies envisaged in subsection 1. So the internal remedies will be the remedies that is available for the specific organ of state. But also interestingly, if you look at subsection 3, says an application referred to subsection 1 must be submitted to the procuring institution within 10 days of the date the bidder is informed of the decision of the award. I know a lot of tender adverts have this statement to say, if you do not hear anything from us after 90 days of closure of tender, you must consider your bid as being non-responsive, and we leave it there. Well, it helps because sometimes some institutions receive a high volume of bids and they won't be able to communicate with everyone. But I think this one now, it makes us to start thinking of creative ways to inform bidders of the awards that we have made, because now we know that there is that 10 days window period of which bidders can actually lodge these complaints or maybe litigations. So maybe you can decide to put it on your website, or maybe we can decide, I mean, we know that we have a tender portal from National Treasury. The question is how easy it is for the bidders to also access that. In municipalities, MFMA make it a requirement that awards must be put on the municipal website. So then one would have to actually consider that, because we don't want a situation where then organs of state are then accused of not informing the service providers well on time, whereby they can be able to litigate decisions that have been taken. Oops, what happened there? Right, departures. Departures now is I would think some sort of an exemption. If you look at this this section, I found it very interesting as well. The Public Procurement Office may, with or without condition, authorize a departure from the provision of an instruction issued. Now, I talked earlier about emergency, and emergency was one of the categories of deviations. One thing that I picked up on this act is that it's not outright in terms of deviation from normal procurement processes. In the MFMA space, deviations are at the act level, where the MFMA outlines when an organ of state can deviate from normal SCM process. In the PFMA space, deviation are at the regulation level, whereby the regulation outlines, and then there were further instruction notes that guides on how can one deviate. And within the deviation, we used to even have categories of deviation: emergency, sole supplier, your animal for the zoo in terms of municipalities, urgent, and all of that. So now we don't have that in the act, at the act level. We only have emergency, and that's it. And then now we're talking about departures. Departure from a instruction, whereby an organ of state may, with or without condition, authorize, a public or procurement office can authorize a departure if it is impractical to comply with the instruction. You'll remember I spoke about local content. Local content, when you request a waiver, which is something similar, you will request to the Minister of Trade and Industry. But this one is any other departure outside local content. If it's impractical to comply with the instruction, the market condition or behavior do not allow for effective application of the instruction, or national security could be reasonably expected to be compromised. So that's when you can actually request for a departure. And one thing similar about this departure, which one can sometimes may think that it's a deviation. If you look at section 4, it further says, if a departure is authorized in terms of section 1, the Public Procurement Office must within 14 days inform the Auditor General and publish the departure. So what then happens is that if the Office of the Chief Procurement Officer gives you that exemption, they need to inform National Treasury, Auditor General, and also publish it. But in terms of deviation, another thing about deviation, which Shaun touched a bit also on procurement methods, deviation is a procurement method. So we are hoping that when we get to the regulation space, when they look into procurement methods, we will actually find deviation also maybe guiding us on how to deviate from normal SCM processes. And I did talk about deviation now. Currently, this is a snippet from regulation, whereby in the regulation, the Act says, actually the Act said on the section of the regulation, the Act says that the minister may prescribe a regulation on emergency procurement, which may include different types of emergency procurement that may be used, an outline of the planning efforts, the prerequisite for awarding of bids, and options available for the procuring institution. But again, this is only confining it to a definition of emergency. And if you look at emergency, we're talking about danger to life, state security, environment. So any other thing like for buying electricity from Eskom, water from a water entity, or animals for the zoo, works of arts and all of that, we'll see in terms of the procurement methods or the regulation, how the minister will try to fit it in. If not, then maybe it might be left on the organ of state to actually cater for in their policies. Instruction notes, the acts now make it a requirement for the Office of the Chief Procurement Officer, which is the Public Procurement Office or Provincial Treasury, before making an instruction published. Making that instruction, they must publish a draft instruction, a statement explaining the need for an intended operation of the instruction, a statement of the expected impact of the instruction, and a notice inviting submission in relation to the instruction and stating the form and manner in which the submissions are to be made. So now, that instruction note, before it comes out, it needs to be also taken out for public consultation for those affected by instruction, or even anyone in the industry can make comments on that. And with each instruction, the Public Procurement Office or Provincial Treasury must publish a consultation report. A consultation report referred to in paragraph A must include the general account of the issues raised on the submission made and response to the issues. So basically, if you've been following the way the procurement bill has been put together, there are instances where comments and inputs are made to the procurement bill, and National Treasury had to actually respond to those comments that have been made. So this is something similar to how then the instruction notes will be done. I wonder how is that going to be managed in terms of now them dealing with all the inputs and everything or maybe they might have an instruction for different categories of procuring institutions, because that's another conversation that we're having to say, shouldn't there be also different categories of procuring institution, whereby maybe Eskom being the only sole supply of electricity could be categorized as a institution type A, and then you'll have instructions that will talk to Eskom, and then in that way, they might be able to manage this whole consultation report better. And
what will guide the procuring entity to determine what is to be set aside? Hope Thandy and Shaun are taking note of that. And then I'll also take another question. There it's I think this one is addressed to Shaun specifically. Thanks for the insightful presentation, Shaun. A few questions on my end. Can you outline the key changes this bill introduces compared to the existing legislation? What are the expected economic impacts of the new procurement bill on local businesses? In what ways does the bill aim to promote economic transformation and social equality? Oh, it's a mouthful. What supporting mechanisms are in place or will be needed to help organizations transition to the new requirement? And then GNU, a hot topic right now in South Africa. Will this have any impact on the bill or the bill being passed? And lastly, how has feedback from various stakeholders influenced the current draft of the bill? That's addressed to Shaun. So I think let's take, because this one is a lot, let's take the two. If Shaun can answer this long one, and then Thandy can deal with the set aside. So over to you, Thandy. Let's start with Thandy, then Shaun.
Okay, Thandy first.
Yeah.
Okay. Thank you, Doctor. The set aside, if you can look at the bill, it's where it actually talks a lot to the Black Economic BE Act, Triple BE Act, actually. So in that section, it talks to the minister having to identify those categories. So if you look at subsection 17E, it talks about the person referred to whom these contracts can be set aside for. There's a list of them: Black people, Black women. Sure, there are many. But to answer the question, yes, there would have to be a market analysis for that, because the current challenge we're sitting with the preferential procurement regulation is that the specific goals that we are having are not informed by data. So you don't want a situation whereby you set aside something for people that don't exist. So that will come back to market and commodity analysis in terms of how it needs to be done. But this paragraph for set aside, it talks more on the broad-based Black Economic Empowerment Act. Thank you.
Thank you. And the set aside provision, it implies that market research will be done, but it is explicitly described under the pre-qualification that market research must be done. So it's an interesting one in the act, and it's really because they're going to tier it. They're going to have set asides at the small, pre-qualification for bigger tenders, subcontracting for bigger. The intention is to tier it. I wonder if I could, Dr. Makole, also just respond to Juliet's question on how is it now, and then move into the key changes question that Sonke is asking. So right now we've got.
Go ahead.
Is that okay? So we've got 5 pieces of primary legislation. So we've got our constitution, one of the few in the world where it mentions procurement, and then we've got 5 different pieces of legislation. At least there's many more, but 5, and it's one that focuses on local government. Municipalities, metros, district municipalities, one that focuses on national provincial departments and public entities, one that focuses on preferential procurement, the mechanism for preferential procurement. We've got another one that focuses on procurement for provincial legislatures and parliament. And then we've got another one that focuses on construction. Now, it's very fragmented, and we have a lot of duplication between them. We have sometimes we have complications and uncertainty between them. And so one of the big changes is that this will be replaced primarily. There will still be some that will be left behind, but primarily with one act. So primarily the Preferential Procurement Act, all the legislation under the PFMA and all the legislation under the MFMA will be combined into one. There will be two that will still be left, but that will make a significant impact on the level of fragmentation that we've got in our legislation for public procurement. What are the key changes? Well, one of the key changes in that is there's a significant piece of legislation in the PFMA that doesn't apply to a massive part of the public procurement community. So in the PFMA, there's a regulation called Regulation 16A. And 16A is where the detail is, although it's only 7 pages, but it's as much detail as we have. And that detail talks about things like bid committees and competitive bidding and piggybacking and transversal agreements and various things like that, codes of conduct. But that does not apply to the 1920 Schedule 2 entities that we've got, all the PFMA Schedule 3Bs and 3Ds, the SABSs of the world and the different water boards that we've got. And so one of the massive changes is that those entities that currently have very, very little regulation that governs them from the procurement perspective, they are going to have to now toe the line and fall into a much more regulated environment that we've got. What are some of the key changes? Some things that we've got in the new act, which we don't have before, is this focus on methods and procedures. It's not there. There are four pieces of legislation currently, which talks about bidding, deviating from bidding, piggybacking, and transversal agreements. And that's it. And so we're moving into a world where every procurement process is going to have a method and procedures that will be legislated. Massive change. I'm not sure we understand what that will bring. Of course, very new is the tribunals. We do not have a tribunal mechanism right now in South Africa, so that will come in. It is operational in KZN, and that will be something that we will be able to see across the country. And then the big change on the preferential procurement policy framework, where that framework now moves towards mechanisms which are internationally accepted, such as set-asides and pre-qualification, compulsory subcontracting. Internationally accepted mechanisms for preference have been brought into our mechanism now, which we've not had before. And so that's new. The change, though, will be that we will no longer have this premium mechanism that says we are prepared to pay a premium for transforming the suppliers that are out there, because we recognize that the small family-owned business in the rural entity cannot compete price-wise for a massive conglomerate that's listed on the New York Stock Exchange. It's very difficult for them to compete. Unfortunately, starting to answer one of your questions around the economic implications of this, that mechanism of recognizing a premium is going to fall away. But it will be replaced by this mechanism that says, well, we're going to be able to set aside and pre-qualify. Those are some of them. I'm not going to get into more. I think your question on the economic social transformation. So we've got now mechanisms that we've always been wanting. Is that ability to say, hey, this deal is just for Black youth in our municipality. We can bring locality into it. We can bring all the demographics into it. We've never had that ability to do it. The only thing that we had in 2017 was on the triple BE level. Hey, you can only bid for this if you're triple BE level 1 or level 2. And we know there are many organizations which are very, let's talk race, very white dominated, that have got a level 1 or level 2. And so we weren't happy that we had the right kind of mechanisms. We've got very powerful mechanisms now that Sonke, that will help with this impact of the GNU. Look, the bill is sitting on the president's desk. There's nothing stopping him signing it at any point in time. My understanding is, and we've had a lot of discussion with the different legal people around the country, is he doesn't even have to go back to Parliament and say, hey, can I still sign this thing? No, it's there. He has the prerogative. He can sign it at any point in time. However, should he say, look, I see this bill as great. However, I've got a concern here, here, and here. And so what I'm going to do is, there are a couple of options. He can refer that, if it's a constitutional issue, he can refer that then to the Constitutional Court and say, hey, Constitutional Court, I've got these constitutional questions here. Can you please resolve that for me? So that's the one option the president has, but it's not a GNU issue. The other option is he might say, look, I've got these issues here. Let me refer it back to Parliament to sort these things out and make us comfortable that these issues and these risks that I see in the bill can be avoided or solved. And I think that's where, and that's why it will not go back to the GNU. I do not think it's going to go back. I think, because we know the DA said previously, the DA, there were a couple that said they do not support the bill in its current form. That DA is now part of the government of national unity, so I think it's going to be very difficult if the president does send it back. What use did the feedback and stakeholders have? I can tell you that it was very significant. I personally was involved in multiple sessions. I presented to both National Assembly. I also presented to the NCOP, and they listened, and National Treasury listened. There were things in the bill that I was not happy with, and I spoke, and I had one-on-one discussions with Treasury, not one on many. I was the only one there, and all the Treasury people were there, and to explain why I was unhappy with those things, and they understood and they recognized that and took those things out. So there were many. And if you just look at, I think the original version of 2020, February 2020 version was about 80 pages. It's now down to 35. That's not because Treasury just decided. It was because Treasury had feedback on a whole range of things. And that feedback then was taken to heart, and there were changes. Some of the things they did not buy into, and they stuck to their guns, and that's still there. And I think that we will be able to manage those things from a regulation perspective. But I hope that answers a very long question. Very important question from Sonke.
Yeah, thank you. It was the longest one. Looking at time, I will ask that our speakers be precise on the following questions in responding to them. And then Sonke, please note there is a request or a need for sharing the presentations as well as the recorded session. So you can take that in as part of your closing. And then I'll quickly take a few questions from the chat and for our speakers, and we'll see how far we go. We are left with 14 minutes, but let's see what can we cover in that regard. One question says, one of the criticism of the PPB is that it makes reference to strategic sourcing, but is silent about strategic procurement, which is supposed to be the focus, as that position the procurement/SCM function as such. What's Shaun's take on this? Then the next question, talk to the reporting structures of supply chain procurement, which is not addressed in the bill, for it to report directly to the CEO. So it's actually a remark. So it's not a question. And then the next question is, are provinces also going to have their own procurement, public procurement offices? From my understanding, this already exists, but we can get clarification in terms of that. We do have offices of procurement, which are based in the provinces under provincial treasuries. Then we've got Juliet saying, I am Juliet, joining from Kenya. I teach public procurement in Kenya and would like to know, how was public procurement in South Africa regulated before this act? Then I'll take 2 more questions and then we can then get to answers. From Dr. Wetzi, based on Section 6A and Section 6B of the Procurement Bill, what are the specific criteria and process for procuring institutions to submit a waiver request if the required quantity of goods cannot be wholly sourced from local manufacturers or does not meet the designated local content threshold? Additionally, how should the institution proceed if the responsible minister does not respond to the waiver request within 30 days? Will the failure to honor the 30-day turnaround by the minister impact the service delivery of the procurement function, potentially adding an additional layer of red tape? In reference to Section 23.1 and 23.2, what measures can a procuring entity prescribe for supplier preference as a condition of the contract, and how should future deliverables and associated penalties be structured within the contract to ensure compliance and achievement of set milestone by the supplier? So I'll leave it at that, Shaun and Thandy, and then let's be short on our answers so that we can take few more that are still there. It's 19 minutes past 5. Thank you. Over to you.
I'll quickly take one part and then Shaun will take the other part. I think on the waiver, I did indicate that if the minister does not respond in 30 days, we'll assume that the waiver has been granted. So it's there on the act. And then on the issue around Section 23.1, in terms of those preference conditions that you can put there, one can look into labor intensive project, one can look into job creation for local communities. It could be anything, because the nice thing about even the section on the set aside, there's a list of categories that are identified for preference, and one can also look at those categories, obviously being informed by market analysis. If they are there, you can actually promote them. And then lastly, on the issue around provinces, in terms of the Office of the Chief Procurement in the provincial level, we currently do have CPOs in the provinces, and the Act still recognizes the provincial treasury and still gives them authority to give instructions to organs of state. Thank you. Over to you, Shaun.
Thanks very much. Ronald, your point on strategic sourcing, strategic procurement is well made. There were initial definitions in there. Many of us weren't happy with those definitions. Look, I think we have a framework. We have the starting point of our primary legislation. Yes, we can pick holes in it and we can say this is missing, this is not good, and this is not great. But we have something, and this is going to, in my understanding, this is going to be approved, and it will be something that we're going to work on going forward. I think the message is that we now have an opportunity. We have the framework. We now have the opportunity to say what needs to be in the next level of our legislation, what needs to be in the regulations. And I think it's going to be up to yourself, Ronald, and many of your colleagues in CIPS and elsewhere to start to describe what do we mean by that, and how are we going to make that real, because it refers to it, but it doesn't really provide much direction on how it's going to be achieved. We have to start to help National Treasury put together the best set of regulations which the planet has ever seen in public procurement. The reporting structure, very interesting. It was in the previous version, which was approved by the National Assembly, taken out in the NCOP for the following reasons. So what was approved by National Assembly was that this procurement office in the public procurement office in the procuring institution did not have to report to the CFO. That was the implication of what it said. There would be an office, but it didn't say the office had to report to the CFO. But we criticized that because there was no mechanism that allowed Treasury to provide any more direction on that point, on the capacity, the roles, the responsibilities of that particular office. And we said, and so what Treasury did then, he said, let's just not put anything in this act, and we'll put the details in later. So it's not off the cards yet around the clarity of reporting to CFO or CEO or whatever makes sense for that particular institution. That detail will come later. I think those are the key ones. Quick responses.
Yes, thank you very much. I'll just quickly then take the last few from the chat so that we can tackle the ones in the Q&A. Okay, so we've got a question that was a remark. It seems the bill attempts to introduce uniformity in procurement for different organs of state. However, the bill does not enforce adoption model procurement policy. What will be the purpose of procurement policies play in individual organizations? So that's one question. And then the next question is that what is the significance of changing the title of Chief Procurement Officer to Head of Procurement? Then we also have another question. What is the significance of changing? Oh, I've already touched on that. With regards to standardization, will the bill replace public entities having their own SCM policies to avoid conflict or changes with National Treasury requesting next day compliance? And then is the tribunal going to be housed at National Treasury, or are provinces going to establish theirs within the framework? Then few last questions. Section 36 and 37, no, I think it's Thandy who was responding there. How is the premium mechanism removed when such is an integral part of doing business with emerging suppliers? For instance, middlemen, they are not manufacturers, nor have the liberty of bulk buying, thus enjoying the benefit of economies of scale. And then the last one from the charts is that with the Act now articulating clearly the matter of procurement policy, which makes provision for categories of preference for HDI on the basis of race, gender, or disability, will it still be necessary to be seen to be implementing what BBEE Act calls the organs of state preferential procurement policy? Over to you, Shaun and Thandy.
Thandy, anything you want to pick up there?
Yeah, a quick one on the tribunals. Tribunals will be established by the minister. And as I did indicate about the panel that is being referred to on the Act is actually what tribunals will have. They'll identify panels, which could be at different provincial level, whereby they will be catering. So it's not going to be one tribunal that will cater for everything. There will be different tribunals within different respective provinces, but they are called panels. And then whatever decision taken by that panel will be regarded as a decision taken by a tribunal. And then on the issue around the premium removed, I don't think the premium is removed as yet. We're not sure about that. However, if you look at Chapter 4, let's say for agreement's sake, the premium is removed. It is being replaced by set-asides, by pre-qualifications and subcontracting. Because now, remember, even with the premiums, as much as the premium was there, 30 years later, there still has not been really much transformation. So now, if you now decide to set aside and identify this group and get this group to compete among themselves, either way, you're gonna give an award to that particular entity that's supposed to be promoted. So say we had engagement about whether the 80-20 is gone, yes or no. We're not sure yet, but even if it's gone, set aside as well as pre-qualification are actually a replacement for that. Thank you.
Well, thanks, Thandy. Yes, agree with you. Look, the point on procurement policy is there's recognition that the institutions will have to develop a policy. There's reference to model policies which may be developed by the Office of the Chief Procurement Officer, by the Public Procurement Office. But what is very clear is that Treasury will describe a framework at a national level for procurement, and it will be up to then the different organs of state to put together that policy, that system at the procuring institution level that will achieve that. And there's no reference in there to policy and SOPs and procedures and stuff like that. That will certainly come through as we go. A quick one. The OCPO versus the head of the Public Procurement Office. Right now, there is nothing in legislation that refers to OCPO. It's just something that we refer to, and we know it's there, but there isn't anything in legislation that actually empowers it and says, this is the OCPO and this is what the OCPO cannot do. Now we've got a head of the Public Procurement Office in legislation with specific roles and responsibilities. We can now pack around that specific roles, responsibilities, governance, checks, controls, and things around that particular entity. And it's not necessarily the name change, but it's more the fact that it is there. I cannot see a mechanism in the framework for premium. And I agree with you. I was disappointed when I saw that was gone. It started to disappear in the discussions with the National Assembly, where there was pushback from many parties to that premium idea, but also pushback because the focus of that meant that we'd have a decision that would be made on the basis of price, and so we wanted to try and take that out. So I can't see a replacement mechanism currently in the current piece of legislation, but I think, as Thandy says, we've got to look at this holistically. Yes, we're disappointed. I'm disappointed that it's not there. However, it's been replaced with very powerful mechanisms of set-aside and pre-qualification. And I think they may be more effective than the premium. Because we don't have to worry about a premium if we've said this particular contract is only for small businesses in this region, right? Automatically, those that would be able to compete on price are not included because they're going to be set aside. They will not be part of the set aside. So I think we've got to look at that, and we've got to start getting comfortable with what that might be going forward. Very interesting, the statement on the BBBE Act, section 10.1b of the Act says that the organ of state must apply any relevant code of good practice in the development and implementation of their preferential procurement policy. Now, there's reference in the Act throughout to the Public Procurement Act to the B Act. But there's a statement in the Public Procurement Act that is a trumping clause that said if there's anything out there that contradicts with what we've got in this act will prevail. So I think there's a big chance, there's less of a chance of contradiction and confusion going forward, but it will be interesting to see how that one is dealt with, because it's a tightrope that has been walked by many. Thank you, Dr. Makole. I think we've addressed most of the points.
Thank you very much. Thank you so much. I see we ran out of time, but yes.
Just to come there, I also tried to also respond to some of the questions of the chat as you see that they're disappearing. So I thought I should just indicate there. Yeah.
Yeah, so I think we only have one question, which I will just read out. The rest is addressed, and thanks, Thandy, for that, so that we can close. The last question for today, it says, how practical will it be to implement Section 68 of the Act? Will this not create a vacuum on procurement processes during the review of the Act, given the requirements to consult with various stakeholders? Over to you. Just precise response as we ran out of time.
So if I understand the question, look, everything that we've got in place now, legislation that we've got in place now, will apply up until the point that the new bill and its regulations are effective. So when the president signs, it doesn't mean the bill then is effective. It means that the president will then either in assenting the bill, will say when it is effective, or will say that somewhere down the line, he will decide when it will be effective. So there won't be a gap. We will use the current legislation that's currently in place up until the time that all the legislation is in place. The regulations have been put together and organs of state have been given time to put their policies together, to update their systems and to train their people.
Okay, thank you very much.
Just to add that, Doctor, I think when you look at Section 68, it talks about the review of the implementation of the Act.
Mm-hmm.
So the Act will be implemented. Post that, then you do have a review of the implement, not necessarily about the effective date. And then I think there's a bit of a misunderstanding there. So it talks about the review of the implementation of the Act. Thank you.